The silence inside Federal Courtroom 7 that morning was not ordinary. It carried weight, the kind that settles only when everyone present senses that something irreversible is about to happen. Judge Caldwell adjusted his glasses, closed the final folder on his bench, and looked directly at the defense table. In fewer than 150 words, he delivered a ruling that detonated 18 months of legal strategy in real time, without warning, without recess, and without room for maneuvering. The judge ordered the immediate arrest of 3 defense attorneys, Marcus Webb, Daniel Harriman, and Priya Nakamorans, at the courtroom itself. U.S. Marshals moved instantly. Handcuffs appeared. Chairs scraped back. In seconds, one of the most closely watched federal corruption trials in the country collapsed from the inside. This was not a contempt charge. It was not a procedural dispute. It was the justice system accusing its own officers of criminal conduct while a federal trial was still underway. The trigger was a single piece of evidence that prosecutors would later describe as radioactive, a privileged audio recording, protected under attorney-client confidentiality, internally labeled the Witness 14 tape. No one outside the defense team was ever meant to hear it, but somehow, it escaped the sealed boundaries of the court. First, fragments surfaced on whistleblower platforms, then full segments spread through encrypted forums. Within days, major news networks were broadcasting portions during primetime coverage. At that moment, Victor Ashworth's trial stopped being about corruption allegations against one man. It became a test of whether the legal system could survive exposure to its own internal rot. What the tape revealed was not aggressive advocacy. It was not ethical gray area. Prosecutors argued it documented an active criminal conspiracy. Marcus Webb's voice dominates the early moments of the recording, calm, controlled, and unmistakably confident. He speaks about cooperation, but not in legal terms. He says cooperation has consequences. Then he clarifies, not legal consequences, personal ones. The timing is critical. This conversation takes place days before Witness 14 is scheduled to testify. There is no reasonable interpretation where this is benign advice. It is pressure. It is intimidation. The conversation drifts into sealed grand jury material, specific testimony, internal assessments, strategic vulnerabilities. Information that should never exist outside protected filings is discussed casually, as if the courtroom walls no longer matter. For Judge Caldwell, this alone represents a catastrophic breach. But the tape continues. A third voice enters the recording, and the tone changes. The speaker does not talk about the witness directly. He talks about the witness's family, his wife's employer, his child's school enrollment, residential stability. The phrasing is precise and chilling. The family situation has been made clear to him. He understands what's at stake. No explicit threat is spoken. No violence is mentioned. And that is exactly why prosecutors say it qualifies as witness intimidation. It is surgical. It is designed to be deniable while still being unmistakably understood. Then the conversation turns to money. Daniel Harriman and Marcus Webb discuss payment arrangements with unsettling familiarity. Webb explains that the retainer covers everything, that the structure runs through a consulting LLC, and that nothing traces back. His tone suggests routine, not improvisation, as if this system has been used before. Within hours of the tape being played in court, prosecutors introduced financial records subpoenaed earlier that same morning. The figures are staggering. $847,000 in wire transfers, offshore entities layered through shell structures, and a direct financial connection to Victor Ashworth's business partner. At this point, the courtroom is no longer watching a defense unravel. It is watching a second prosecution form in real time. The most disturbing revelation comes later in the tape. The attorneys discuss a different witness in an unrelated case. The language is operational, almost procedural. They talk about consequences, about making an example, about ensuring compliance. To investigators, this suggests something far more dangerous than a single corrupted defense team. It suggests a repeatable, system and organized method of witness intimidation that may span multiple cases and years. When the FBI's lead forensic audio analyst takes the stand, any remaining doubt collapses. The recording is authenticated as continuous and unaltered. Voice analysis confirms Marcus Webb and Daniel Harriman with 99.2% certainty. No editing, no manipulation, no plausible deniability. Then comes the revelation that changes everything. The recording device was not planted by law enforcement during a raid. It was placed by a junior paralegal working inside the defense team, someone who had been, quietly cooperating with federal prosecutors for months. Every private meeting, every assumption of confidentiality, every careless word, all of it preserved. At that moment, Judge Caldwell's decision becomes inevitable.